الأخوات والأخوات السلام عليكم ورحمة الله.
Dear brothers and sisters, may the blessings of God be upon you all. I would like to welcome you on behalf of the Arab Center to discuss the decision by the Trump administration to recognize Jerusalem as capital of Israel, and the following decision of moving the date of moving Jerusalem as capital to May. First of all, please, 1 minute of silence in recognition of the martyrs fallen in eastern Ghouta in Syria. Thank you. Dear brothers and sisters, after 7 decades of American policy towards Jerusalem, which did not recognize Jerusalem as capital of Israel, the Trump administration has taken this decision and directed the State Department to make the necessary arrangements to implement this decision. This is a decision which was taken previously by the Congress in 1995.
إلا أن ذلك القانون تضمن بندا يسمح للرئيس الأمريكي بتوقيع إعفاء مدة 6 أشهر إذا رأى أنه ضروري لحماية المصالح الأمنية القومية للولايات المتحدة. ومنذ إدارة الرئيس بيل كلينتون والإدارات الأمريكية المتعاقبة توقع الإعفاء تلقائيا كل 6 أشهر، على الرغم من أنهم كانوا قد وعدوا مثل ترامب بوصفهم مرشحين بنقل السفارة من تل أبيب إلى القدس بعد توليهم منصب الرئاسة. تداعيات القرار الأمريكي أخذت تظهر تباعا من محاولة إسرائيل إقرار قانون لفرض السيادة الإسرائيلية على الضفة الغربية إلى مصادقة اللجنة الوزارية لشؤون التشريع في الحكومة الإسرائيلية الأسبوع الماضي على مشروع قانون يتيح سحب الإقامة الدائمة من المقدسيين، حيث يتيح التشريع الجديد في حال إقراره من الكنيسة أو في الكنيسة للحكومة طرد أي مواطن من القدس لأسباب سياسية. مشروع القانون الجديد سيضاف إلى سلسلة من القوانين والأنظمة التي هدفت إلى تقليص عدد الفلسطينيين في القدس وزيادة عدد المستوطنين، مثل القوانين الخاصة التي تقيد الإقامة والبناء والسكن في القدس. وكان القانون الأول الذي أقرته إسرائيل عقب احتلالها عام 1967 هو قانون الإقامة، واعتبر بموجبه المقدسيين مقيمين في المدينة وليسوا مواطنين، ونص القانون على سحب حق الإقامة من كل مقدسي غير عنوانه وأقام في أي منطقة أخرى من الأراضي الفلسطينية أو أي مكان آخر في العالم. وفق إحصاءات عديدة فإن إسرائيل سحبت حق الإقامة من 14,900 مقدسي منذ عام 1967. هذه التداعيات القانونية والديمغرافية والسياسية لقرار ترامب بالاعتراف بالقدس عاصمة لإسرائيل سيتم تناولها في هذه الندوة من خلال 3 جلسات تتناول هذه الموضوعات المختلفة، ومن قبل مجموعة من الخبراء يتناولون بالتفصيل هذه القضايا، وفي جلسة نقاشية ختامية نحاول مناقشة سبل مواجهة هذا القرار. أرحب بكم من جديد وأتمنى لكم كل الفائدة وشكرا جزيلا لكم. أترككم الآن مع الجلسة الأولى. أدعو الدكتور محمد الخليفي إلى ترأسها.
بسم الله الرحمن الرحيم. الحمد لله وكفى، وصلاة وسلاما على عباده الذين اصطفى. السيدات والسادة الحضور الكريم، أحييكم جميعا بأطيب تحية وأطيبها السلام، فالسلام عليكم ورحمة الله. كما تفضل الأستاذ الزميل في تقديم البداية، كما تعلمون بأنه في 6 ديسمبر من العام المنصرم أعلن رئيس الولايات المتحدة الأمريكية دونالد ترامب الاعتراف بالقدس عاصمة لإسرائيل، وأعلن أيضا خبر نقل السفارة الأمريكية إلى القدس. جاء هذا التصرف أو الإعلان كتصرف أحادي الجانب من الولايات المتحدة الأمريكية، فيثير مجموعة من التساؤلات القانونية. هل هذا التصرف كامل وسليم من الناحية القانونية أم لا؟ ويطرح عدد من التساؤلات. هل خالف فعلا هذا الإعلان الأمريكي ميثاق الأمم المتحدة والمعاهدات الدولية في حقها بشأن ما قررته هذه المعاهدات من حق الشعوب في تقرير مصيرها ومستقبلها السياسي؟ هل خالف هذا الإعلان بالتحديد فتوى محكمة العدل الدولية الموجهة إلى الجمعية العامة للأمم المتحدة بشأن عدم مشروعية جدار الفصل العنصري الإسرائيلي في الأراضي الفلسطينية؟ هل قوض القرار مجموعة الجهود للأمم المتحدة المبذولة من أجل التوصل إلى حل عادل للقضية الفلسطينية؟ هل خالف الإعلان الأمريكي قرارات منظمة اليونسكو وغيرها بشأن الاعتراف بالقدس أرضا فلسطينية محتلة؟ هل خالف أيضا القرار مبدأ قانونيا أساسي مفاده أن الاحتلال لا يستتبع نقل السيادة على الأرض المحتلة، فلا تملك سلطة الاحتلال حق ضم الإقليم أو تعديله أو هيكلته؟ مجموعة حقيقة من التساؤلات القانونية في هذا المحور الأول لهذه الندوة، نتركها حقيقة لنخبة من المتحدثين معنا اليوم. واسمحوا لي أن أبدأ بالمتحدث الأول، وهو الدكتور أنيس قاسم، وهو محامي مقيم في عمان ومؤسس لمكتب قاسم للمحاماة، حاصل على شهادة الدكتوراه في القانون من جامعة جورج واشنطن عام 1977. عمل مستشارا قانونيا للوفد الفلسطيني المفاوض في مدريد وواشنطن، وقد كان أيضا عضوا في هيئة الدفاع الفلسطينية أمام محكمة العدل الدولية في قضية الجدار. عمل رئيس التحرير ثم مستشارا للكتاب السنوي الفلسطيني للقانون الدولي عام 1984، كما أنه عضو مجلس أمناء جامعة بيرزيت والجامعة الأردنية. فليتفضل الدكتور مشكور.
شكرا أخي محمد على هذا التقديم، وما عددته من قرارات جميعها تم خرقها بلا تحفظ من قبل الرئيس الأمريكي. في 6 ديسمبر 2017 ألقى الرئيس الأمريكي بيانا اعترف بموجبه القدس عاصمة لدولة إسرائيل. وقد ساق الرئيس في تبرير قراره 3 أسباب أو تبريرات، وهي جديرة بالفحص والمناقشة على ضوء مبادئ القانون الدولي. قال في السبب الأول أن الرئيس الأمريكي يستند في هذا البيان بقوله أن إسرائيل دولة ذات سيادة ولها الحق كأي دولة ذات سيادة بأن تحدد عاصمتها. هذا القول فيه تزوير، لأنه قال نصف الحقيقة. من الثابت أن لكل دولة الحق في أن تشرع ما تراه مناسبا، ليس فقط فيما يتعلق بعاصمتها، إنما تشرع أي قانون تراه مناسبا ولمصلحتها، إلا أن هذا الحق ليس طليقا من أي قيود. وكل دولة تود أن تشرع قانونا يجب أن تعي أن المجتمع الدولي ملزم بمبادئ محددة، لا تستطيع الدولة أن تتجاوز هذه المبادئ حين تشرع قانونا وطنيا. هذا القيد الوارد على حرية الدول في التشريع تطور قديما، والآن أصبح جزءا لا يتجزأ من القانون الدولي العرفي. وشرحا بسيطا لكلمة القانون الدولي العرفي، أنه قانون يتطور حسب الممارسات الدولية ويصبح ملزما للدول دون أن تضطر هذه الدول لتوقيع معاهدة أو تعلن إقرارا بقبولها هذا المبدأ. هو يصبح مفروضا عليه كدولة أو كشخص من أشخاص القانون الدولي. على سبيل المثال في عام 1862 كانت كوبا، جزيرة كوبا، كانت تحت السيادة الإسبانية، وفي تلك السنة شرعت إسبانيا قانونا جعلت المياه الإقليمية لجزيرة كوبا 6 أميال، علما بأن المجتمع الدولي قد تواطأ قبل ذلك على اعتبار المياه الإقليمية 3 أميال. والدولة التي احتجت على هذا التشريع هي الولايات المتحدة الأمريكية، وقالت لا تستطيع دولة أن تستند لقانونها الوطني لكي تمد صلاحياتها كما يحلو لها خارج نطاق 3 أميال. في قضية مشهورة في 51 اسمها قضية الفيشريز، قالت محكمة العدل الدولية أن التشريع، قالت إنه تحديد المناطق البحرية لا يمكن أن يعتمد على إرادة الدولة الساحلية لوحده، ولو أنها كانت تتصرف بموجب تشريع داخلي. إن تصرف الدولة الساحلية يجب أن يستند إلى القانون الدولي. هذا فيما يتعلق بقانون البحار. فيما يتعلق بقانون الجنسية مثلا، نصت اتفاقية لاهاي حول مسائل الجنسية الصادرة في عام 1930 في المادة الأولى على أنه تختص كل دولة بأن تحدد في قانونها الأشخاص الذين يتمتعون بجنسيتها، وتعترف الدول بهذا القانون بقدر انسجامه مع مبادئ القانون الدولي. وهذا القيد واضح على سلطة الدولة حين تشرع قانون معين. يعني لا تستطيع دولة مثلا مثل قطر أن تقول لا يمكن تجنيس القطري إذا كان زنجيا مثلا، لأن هذا في مخالفة للاتفاقيات الدولية. اتفاقية فيينا الخاصة بالمعاهدات بين الدول نصت في المادة 27 بقولها لا يحق لدولة أن تتذرع بقانونها الداخلي لكي تبرر إخلالها بالتزام دولي. وآخر دليل على صحة هذا المبدأ أن إسرائيل في عام 1980 شرعت قانون أسمته القانون الأساس باعتبار القدس عاصمة لإسرائيل. لم تعترف دولة واحدة بهذا القانون الوطني الإسرائيلي، وذلك لاعتبار المجتمع الدولي، اعتقاد المجتمع الدولي أن هذا القانون يخالف القانون الدولي، لأنه لا يجوز لسلطة احتلال أن تغير الوضع القانوني لأرض محتلة كما يحلو لها. وأول الدول التي نازعت في ذلك الولايات المتحدة الأمريكية، وحين أصدر مجلس الأمن الدولي قراره في عام 1980 القرار 468، لم تمارس الولايات المتحدة حق الفيتو. كان بإمكانها أن تمارس وتسقط ذلك القرار، إلا أنها لزمت الصمت. وهنا يمكن النظر إلى أن القرار الأمريكي بالاعتراف بالقدس واعتبار أن إسرائيل دولة ذات سيادة ولها الحق أن تشرع كما يحلو لها، هذا القول قول يتجافى مع مبدأ أو كافة الثوابت القانونية في القانون الدولي. وننتقل الآن إلى القول أو التساؤل حول ما هي القدس التي يعترف بها الرئيس الأمريكي. نحن نعلم أنه بعد احتلال القدس عام 1967 أصدرت إسرائيل 3 قوانين بعد احتلال القدس بيومين. واحد من هذه القوانين وسع منطقة القدس ووسع حدود البلدية، فبعد أن كانت حوالي 6 كيلومتر مربع أصبحت 64 كيلومتر مربع. هذا يعني أن إسرائيل قضمت من الأراضي الفلسطينية المحتلة اللي هي أراضي الضفة الغربية حوالي 20% وضمتها إلى القدس. فعن أي قدس يتحدث الرئيس الأمريكي؟ هل يتحدث أيضا عن القدس الموسعة؟ القدس التي يتحدث عنها الرئيس الأمريكي ولا سيما القدس الشرقية هي في القانون الدولي أرض محتلة، وعلى ذلك جرى العمل والتصويت في الجمعية العامة للأمم المتحدة، في مجلس الأمن الدولي، في المجلس الاقتصادي والاجتماعي برضو هو أحد مؤسسات الأمم المتحدة، في منظمة اليونسكو، وختامها في الرأي الاستشاري لمحكمة العدل الدولية، وهو أهم صيغة قانونية وفتوى قانونية صدرت فيما يتعلق بالأراضي الفلسطينية المحتلة. المحكمة قالت إنه القدس الأراضي المحتلة هي الأراضي التي تقع بين الخط الأخضر اللي هو خط الهدنة في عام 49 وحدود فلسطين الشرقية، ودائما تضيف في الأراضي المحتلة بما في ذلك القدس الشرقية. وهذا التعبير الأراضي الفلسطينية المحتلة بما في ذلك القدس الشرقية تعتبر نص نموذجي في كافة القرارات التي تصدر عن المنظمة الدولية بكافة أجهزتها. الغالبية العظمى من فقهاء القانون الدولي أيضا على إجماع، فيما عدا بعض الإسرائيليين وليس جميعهم، بعض الكتاب القانون الإسرائيليين وليس جميعهم، يؤكدون أن الأراضي الفلسطينية هي أراضي محتلة بما في ذلك القدس الشرقية. هذا يعني يترتب على هذا الوصف شيء واحد، أن إسرائيل ممنوع عليها أن تغير الوضع القانوني والجغرافي والديمغرافي لمدينة القدس. هذا القرار الأمريكي
This U.S. decision recognizing Jerusalem, an occupied territory, as the capital city of Israel is as if the U.S. administration is legitimizing the occupation, making it lawful, and this creates a burden, responsibility on the United States. And the international law, there is the Code of Legal Responsibility of States. Any state that acts illegally has an international responsibility, and this responsibility might impose on the state a series of commitments to include damages or compensation. And the United States, by legitimizing the occupation of Jerusalem, becomes partner. So the Article 16 of the Code of International Responsibility is applied. It says any state that assists or helps any other state to act illegally has the responsibility, or it is considered responsible internationally, should this state act knowing the circumstances surrounding this case. In this case, the United States President knows what are the circumstances and the conditions in Jerusalem, particularly the eastern part of Jerusalem, and it is known that this part is an occupied territory. The second reason behind this decision, as explained by Mr. Trump, he said this is truth, in reality, important condition to achieve peace. The U.S. President is saying that the situation of Israel is a fait accompli, and Jerusalem needs to be recognized as the capital city of this state. This is not true. Why? Because the international community, after the defeat of 1967, the international community, to include Arab states, that the decision 242 is at the base of any solution. Israel is a state in the Middle East and has the right to exist within safe boundaries. And that was the unanimous decision of the international community, and this is how the decision 242 or resolution 242 was adopted, and it became the basis of the peaceful solution of all aspects of the Palestinian-Israeli confrontation in the Middle East. Resolution 242 is based on a very important legal principle when it comes to international law. It was created in the 1920s. It states that the principle criminalizes the acquisition of the territory of others by force. This Resolution 242 says that if we legitimize occupation, this decision or this resolution becomes void, as if it was retracted by the international community. This legal principle is still the foundation of peacekeeping at the international level and preserving the peace and security at the international level, and it is the foundation of the new order in the world and the Charter of the United Nations. And even the International Court of Justice highlights this principle. There's also another case, the famous Nicaragua case. This court stated that criminalizing the acquisition of the territory of others by force is part of the customary international law. As to the third reason, as explained by Mr. Trump, it is 70 years ago the United States under Harry Truman recognized the state of Israel. And since Israel considered the capital city Jerusalem, and the US president said or added the capital city that was created by the Jewish people long ago. Mr. Trump's reliance on the recognition of President Truman is actually against his own explanation or argumentation of his decision. Why? Because when Truman was presented with this document to recognize Israel as a Jewish state, as was considered, and before signing, he actually changed Israel, changed the word Jewish and added the state of Israel, so instead of a Jewish state. And the First Amendment of the US Constitution, it prohibits any federal institution or in the United States from dealing with anything that's got to do with religion. Religion is a personal issue, and official federal institutions in the United States are prohibited from dealing with religious aspects. Even the representative of the United States during the resolution of 181 in 1947 sent a letter to the Department of State saying that the suggestion is to recognize a Jewish state and an Arab state. And we cannot, according to our constitution, recognize any state with a religious aspect. This is why I cannot vote in favor of this resolution. Ever since, the United States was very sensitive regarding the word Jewish state. And this is why the US president talked about the capital city of the Jewish people long ago. Of course, this is a falsification that is not up to the US presidency, because in old ages, old times, there were no capital cities and there was no Jewish people or any other people. Using the word Jewish people without talking about the peoples of the earth is actually void of any meaning. So when Herzl wrote his famous book, The Jewish State, he said we need to create this people in order to have the right of self-determining our fate. And if we are not people, we cannot recognize or we cannot ask for this right. There's a textbook that Jewish students learn from in the United States, particularly promoted by the Zionist movement. It is a collection of studies of Zionist authors who say we should insist on using the word Jewish people in order to be able to have the self-determination right. However, the US president is prohibited from recognizing or using the word Jewish people, not only in accordance with the US Constitution. There's also a document issued in 1964 by the Department of State of the United States that says that the United States government does not recognize that the concept of Jewish people is a concept that is acceptable in accordance with international law. There's no such thing as the Jewish people as a concept in the international law. So back to Mr. Trump's word. Talking about Jewish people violates the US Constitution and the political commitment and recognition of the United States that there is no such thing as Jewish people. Suppose we accept that Mr. Trump's statement. The U.S. president needs to understand that the word Jewish people is the foundation of the wall of separation in the Palestinian territories in its two parts, 1948 and 67. 2 minutes, please. Okay. The word Jewish people means that in Israel, there's the Jewish people, the Israelis, and the non-Jewish, and anything or all the legislations in Israel are divided accordingly. The Jewish and the non-Jewish. The right of return said every Jewish individual has the right to come to Israel, and the national identity law said any individual coming to Israel to reside permanently is given the national identity of Israel simultaneously when arriving to Israel. As the Palestinians who are living in Israel, they still don't have a national identity card until 1977, and then they were given the Israeli national identity or passport for electoral purposes. When it comes to the Palestinians living outside of Israel, they are prohibited from returning very simply because they are not Jewish. This racist regime is deeply rooted in the laws of Israel. In the West Bank, there's a new apartheid regime, meaning that the settlers in the West Bank are under or subjected to the Israeli law, whereas the Palestinians are subjected to military orders on behalf of Israel. And Ori Saviri, who was behind the Oslo Agreement, said that we are currently creating an apartheid regime in Israel. This apartheid regime in Israel or the occupied territory is a crime according to the international law, because there are agreements regarding the end of apartheid, and Israel is a signatory state. In addition to the Rome Agreement, that was the foundation of the International Criminal Court, it considers apartheid a crime. So the US president is committing a crime in the eyes of the international law. The ultimate question is, why did the US president issue this statement? The answer, actually, I do not know the answer. I will quote from the Greek mythology. Athens woke up one day and saw the library on fire. Residents of Athens rushed to put it up, and they saw a Greek individual who is throwing wood to the fire. And he said, I want to burn the library. They asked him, why do you want to burn the library? He said, because I want my name to become known for ages to come. And this is what Mr. Trump is doing. Thank you, Mr. Anis, for your intervention. But
we also should leave time for our other panelists. And Salma is a specialist in criminal law and provides consultations for governments and individuals. And from 2009 to 2012, she headed the international legitimation or litigation for the Palestinian rights organization Al-Haq. She contributes regularly to the London Review of Books, Reuters, and The Nation. Salma, the floor is yours. Salma will be speaking for 20 minutes on characterizing Israeli policy in Jerusalem as a crime against humanity. Those who need translation sets, Salma will be speaking in English.
Good morning, and thank you very much for having me. And I do apologize for having to speak in English, but I'll speak slowly so that the interpreters, wherever they are, can cope. And for those of you who understand English, then that will be better to have a kind of more direct form of communication. So it was introduced that I was going to speak today about how Israeli policy constitutes war crimes. Just to clarify that the purpose of my presentation today will primarily be to argue that Israeli policy in East Jerusalem, especially that which relates to land and to building and to residency rights, amounts to a crime against humanity rather than a war crime. And there's a bit of a difference between the two, and I hope that the significance of speaking about crimes against humanity in particular will become clear through the course of my presentation. And I will focus particularly on the crime against humanity of persecution, but I will also briefly mention the crime of apartheid, as Dr. Anis Kassim did as well. So what I want to do firstly is to explain what a crime against humanity actually is and why it's important, I think, to characterize Israeli policy as a crime against humanity and the advantages of this approach. And secondly, I want to look at the definition of the crime of persecution in a bit more detail and apply that definition to Israeli policy in Jerusalem. And finally, I will briefly suggest that this framework of crimes against humanity is underused in general in Palestinian advocacy, and I will suggest that we should use it more often, both in our legal and in our broader political advocacy. So turning first to defining what a crime against humanity is, for those of you who don't know, it's a type of international crime that was first prosecuted by the Nuremberg Tribunal at the, after World War II, of course then mainly to prosecute the crimes committed by the Nazi regime. And it's now been codified in various statutes of international tribunals and courts. So the tribunals that were set up to prosecute crimes in the former Yugoslavia and during the Rwandan genocide, and more recently in the Rome Statute of the International Criminal Court. And it also exists as a crime in the national laws of many domestic legal systems around the world. So if I look at the way that the International Criminal Court defines a crime against humanity, it says that a crime against humanity is the commission of a crime, and it lists several different types of crimes, or other inhuman acts, which are committed as part of a widespread or systematic attack directed against a civilian population. And an attack, this notion of an attack against a civilian population, is defined as a course of conduct that is committed over a course of time involving multiple acts and is carried out pursuant to or in furtherance of state policy or an organizational policy. And I think that's an important aspect of the definition when we come to talk about Israeli policy in Jerusalem. And widespread, so you have to have also a widespread or systematic attack, and that means an attack which is either, in terms of its scale, it's widespread, it's large, and it affects many people, or it's organized. The way that the crimes are committed is such that they are committed in an organized way. So, and the Rome Statute of the International Criminal Court categorizes the crime of persecution and the crime of apartheid, both as forms of crimes against humanity. Now, if we look at policy in East Jerusalem, I think it becomes clear why crimes against humanity are a useful framework for describing that policy. And I'm not going to go into a lot of detail about the policies themselves. I know you have a session coming up next about that. But very briefly, just to outline the central tenets of the policy that I think are important to emphasize. Many of you will have heard of the so-called demographic policy for Jerusalem, the 70-30, I think it was then more recently amended to the 60-40 policy, which says, and this is official government policy at the national and the municipal level, which says that in effect, there needs to be always maintained a demographic balance of 70% Jews to 30% Arabs in Jerusalem, and then amended to 60% Jews to 40% Arabs. And this policy exists in order to consolidate Israel's annexation of East Jerusalem, or in fact of the whole city of Jerusalem, and is essentially a policy of Judaization. Now, in order for that policy to be achieved, that objective of the 60-40 ratio to be achieved, we know that various different policies and practices are implemented. So on the one hand, there are the transfer of Israeli settlers into East Jerusalem. So that's the carrot, in a way. That's the way to get the percentage of Jews in the city up. And in order to get the percentage of Palestinians down, you have several different policies that interact with one another and that build upon one another. In particular, you have the creation, essentially, of a deliberate housing shortage in the Palestinian sector through the appropriation of land and the creation of harsh living conditions, such as restrictive zoning for Palestinian areas, demolishing of homes that are then built, quote-unquote, illegally, and a denial of sufficient municipal services to Palestinian localities. All of that creates a pressure on Palestinians to leave the city. You then have, as well as on top of that, the center of life policy, in which Palestinians not living in the city for a certain number of years have their residencies revoked. And you have a lack of family unification for Palestinians, so spouses from who do not have Jerusalem IDs are not allowed to come and live, by and large, with their partners in Jerusalem. And all of those things conspire to create conditions where Palestinians either have to leave, or if they leave, they can't return. And eventually, many will have their residencies revoked. And so all of those things are done to ensure this demographic policy. Essentially, Jews in, Palestinians out. And in implementing the policy, we know that there have been many, both criminal acts and also what would be described more broadly as inhuman acts, have been committed over the course of 4 decades at least against Palestinians. So we know about the thousands of Palestinian homes that have been demolished, thousands of residencies that have been revoked, thousands of forcible displacements of Palestinians even within Jerusalem when their homes are demolished. So what we see, in other words, is a state or organizational policy which has been enacted and has resulted in the commission of a multiplicity of crimes or other acts carried out over a long time and on a large scale, and affecting a civilian population, namely the Palestinian civilian population. So I hope that makes it clear why the Crimes Against Humanity framework is a useful and appropriate one to apply to Israeli policy, because it is able to describe the organized nature of the crimes that are committed and their large scale, and the fact that they happen pursuant to a policy involving the state apparatus. And in that way, I think they describe Israeli policy in a much more accurate way than is possible if you speak only about violations of humanitarian law on an individual basis, or even the commission of war crimes, which by their nature are also individual crimes. So that's the first advantage, I think, of using the Crimes Against Humanity framework, is accuracy. It properly describes the extent of Israeli criminality in Jerusalem. The second advantage is, and Dr. Anis touched on this, is the fact that it allows us to characterize Israeli policy specifically as criminal, not just a violation of international law, but the commission of a criminal act. And that means, of course, that we can establish individual responsibility of Israeli political leaders and other officials who are involved in implementing that policy. We can establish their individual responsibility for these crimes. And there's always then the potential to pursue prosecutions of those persons, both in the International Criminal Court, but also in national jurisdictions that allow for the prosecution of crimes against humanity. And thirdly, one other advantage, I think, of using the Crimes Against Humanity framework is that it's important to note crimes against humanity can take place during both times of war and during times of peace, and they apply in occupied territory as well as within the territory of a state, the sovereign territory of a state. And what that means is that we can use the same framework of crimes against humanity to discuss Israeli actions in East Jerusalem and the West Bank and the Gaza Strip, which are considered under international law occupied territories, as well as to describe Israeli policies that occur within the Green Line. So, for example, Israel's forcible transfer of Bedouins from the Naqab desert is potentially something that also amounts to a crime against humanity. And this means that we can employ the same framework to speak of Israeli actions in all the geographical locations in which Israeli policy is active. And I think that's really important from an advocacy perspective, because it it encourages, or it takes us closer to speaking about Israel as one regime, and that these different policies that manifest against different Palestinian constituencies as different facets of one regime. So in the time that will remain, which is, how much time have I got? 6 minutes, okay. So I'm going to spend 5 minutes just talking in a little more detail about the crime of persecution and why it applies to Israeli policy. And in the last minute, I will draw up my conclusions. So, persecution in particular, which is categorized as a crime against humanity, is defined as the intentional and severe deprivation of rights by reason of group identity. So I'll just break that down. In other words, it means it happens when a perpetrator commits a crime or some other kind of inhumane act that severely deprives somebody's fundamental rights. And they target the person, the victim, on the basis of that victim's group identity. In particular, it could be their national or their ethnic or their religious or their racial identity. And because it's a crime against humanity, it also needs to be carried out in the context of this widespread and systematic attack against the civilian population that I described, which is relevant to all crimes against humanity. So if we look at the commission of crimes and inhumane acts in East Jerusalem by Israeli officials, I think it's obvious that there are many acts that severely deprive Palestinians of their rights. House demolitions, certainly, forced displacements, land appropriation, and all of these things are crimes. I think it's important, and the reason I chose to look at persecution is it's important to note persecution can also be carried out through actions that aren't technically crimes, but that are somehow in other ways restrictive or deny rights. And this is important when it comes to policy in Jerusalem, because the situation that exists is that Israel imposes many kinds of restrictive measures on Palestinian life in the city, which are aimed ultimately in implementing the demographic policy. In other words, the ultimate objective is to get Palestinians to leave the city as a result of these policies that make it impossible for them to stay. However, due to Palestinian tenacity and resourcefulness, in many cases, they are essentially hanging on to their homes and their residency rights in Jerusalem in spite of all of these restrictive measures. And so, in a sense, what you have is a situation where the crime, the ultimate crime, which is forcible transfer, hasn't yet occurred. But in the meantime, life is miserable. And persecution, therefore, encompasses all of these other restrictive measures that Israel might impose to make life miserable, such as, lack of family unification, not providing sufficient municipal services, different acts of discrimination, allowing settlers to move into Palestinian localities and harass people and the like. So that's the first point to make. Crimes and inhumane acts that deprive rights clearly are being carried out. The second aspect of the crime of persecution and the essence of the crime is the concept of discrimination, that a policy is carried out that targets a particular group on their national or racial or religious identity as a result of their identity. And it's pretty obvious that that discrimination exists in Jerusalem. We see that both in terms of the data and then can infer the existence of a discrimination. In other words, for example, house demolitions are almost entirely carried out against Palestinians and very, very rarely against Jews. And I'm not sure, I think we probably count on two hands how many times an actual residence, a home, has been demolished in the Jewish sector. Whereas in the Palestinian sector, we know that it's amounted to tens of thousands of homes over the years. Discrimination can also be established by looking at the existence of a discriminatory policy that's being implemented. And here again, of course, we have the demographic policy, which in effect is a discriminatory policy because it tries to keep Palestinian numbers down and to ensure that Jewish numbers increase. And I've talked about, so that's why I think we see particularly the crime of persecution happening, because you have the crimes and the inhuman acts, and you have the discrimination. And I've already mentioned the fact that this all happens in the context of a widespread or systematic attack against the population. So there we have the elements of a state policy, large-scale nature of crimes taking place over a long period and taking place in an organized fashion. So I'll just very briefly say, because I know I'm running short of time, that I think a similar analysis can apply to the crime against humanity of apartheid. And apartheid is defined in the Rome Statute as a crime against humanity. The only difference is that essentially apartheid requires inhumane acts to be committed in the context of in an institutionalized regime of systematic oppression and domination by one racial group over another racial group. And I think it's, again, fairly obvious that the institutionalized nature of the discrimination against Palestinians in East Jerusalem that stems from the demographic policy leads to the perpetration of all kinds of inhumane acts, and that constitutes the institutionalized regime that you need for apartheid. And moreover, I think it, somewhat, well, not unusually, but importantly, Israeli policy in Jerusalem, to my mind, is explicit about being aimed at ensuring the domination of one racial group, that is the Jews, over another racial group, that is the Palestinians. You see that not only in public statements, but the demographic policy has that as an implicit component, that really by ensuring greater numbers, you're ensuring domination. So finally, just to wrap up, I hope that I have persuaded you that the Crimes Against Humanity framework is a useful framework for assessing the nature of Israeli policy in Jerusalem and, in fact, against Palestinians in other localities as well. Because of the way that it allows us to describe crimes being committed in this systematic and institutionalized manner and pursuant to a state policy. And so it's a much more coherent and accurate way of characterizing Israeli actions. I will just say briefly that in the literature that I've read that comes out of the NGOs and human rights organizations and international organizations, there isn't very much about crimes against humanity. There's a focus on looking at individual violations of humanitarian law and human rights law, and sometimes there's an analysis of the commission of war crimes during hostilities, especially in Gaza. But there's really very little looking at the commission of crimes against humanity, and especially applying that framework to Israeli policies that are committed in a so-called administrative context. So not in the course of hostilities, but in the course of day-to-day life in the occupied territory. And so I would encourage greater use of this framework and this paradigm generally in Palestinian legal advocacy, and perhaps also more broadly in our political advocacy, because of the way that it helps define actions as criminal, and because of the way that it helps us achieve a unitary framework for looking at Israeli policy both within the Green Line and within the occupied Palestinian territory.
Thank you.
Thanks.
You were running out of time. Thank you so much, Ms. Salma. Salma Ayyoub قدمت لنا توصيف حقيقة حول السياسات الإسرائيلية بالقدس.
Thank you so much, Salma. You have talked about crime against humanity, and we will move to Alaa Mahajna. Mr. Alaa is a lawyer and jurist based in Jerusalem who specializes in settlement issues and Palestinian land, residency and housing rights. Mahajna previously worked as a lawyer at the Adalah Center in Haifa and the Arab Center for Palestinian Rights, and previously served as legal advisor in the Negotiations Affairs Department through the United Nations Development Program. He's a researcher at the Mada Center and holds a master's degree in international law from the University of Virginia in the United States. Mr. Alaa, the floor is yours to tell us about Jerusalem within Israeli law, the prospects for confrontation. Good morning. Good morning. I would like to thank the Arab Center for the Research and Policy Studies for this very important conference, and I would like to thank them for this opportunity to talk about the situation in Jerusalem. Reactions vis-à-vis the Israeli practices in Jerusalem are usually faced with a refusal, as if Israel can do whatever it wants, and from our side as Palestinians this will change nothing. Unfortunately, what is happening on the ground is completely different, and Israel is indeed capable of imposing new status quo and a new fait accompli. And the move of the Jerusalem, or of the embassy to Jerusalem, will take place in 2 to 3 months from now. In addition to the 70-year anniversary of the creation of the State of Israel, I think that this represents 100% that what Israel is doing on the ground is becoming a fait accompli that the other states and countries and the Palestinian Authority has to deal with. So, Jerusalem within Israeli law, the prospects for confrontation. This is my paper. This study will tackle the legal tools used by Israel to control Jerusalem and change its demographic, geographic and status, and by analyzing the most important laws of Israel since 1948, especially that Trump's declaration recognizes and accepts the Israeli practices and includes an approval of what Israel has done since 1948, and it gives it a legitimate aspect. We can actually distinguish between the practices of Israel in Jerusalem by saying that Israel is using political development in order to create a new status or at the service of its colonial strategy and plans, and will move to legitimizing this situation by enacting laws that will help Israel establish and reinforce these laws. When it comes to the structure of my study, it is divided into 3 main themes. The first one, I will be talking about the Israeli law as a mechanism of control. My colleagues talked very briefly about the important Israeli laws, some of them in this field. I will be talking also about the change of the judiciary structure in the last 2 decades in Israel, and then I will talk about the main structure of the turning the city into a Jewish city, so controlling the environment and changing its identity. And the second point is changing the demographics of the city. When it comes to the second theme, I will be talking about the repercussions of Trump's declaration on the situation on status of the city. The first part is the legal aspect, the change of the laws and its influence on this agreement or settlement with the Palestinians. And the third theme will be about the options for confrontation. So, confronting the policies and practices of Israel. And I don't want to talk about confronting Trump's declaration. Trump's declaration accepts the fait accompli that is imposed in Jerusalem since 1948 and 1967. Back to the first theme, controlling the territories and sending the original residents out are the fundamentals of the Israeli project in general and in Jerusalem in particular. The Zionist movement, and after that Israel, after its creation, used several means in order to achieve this objective, and the Israeli law is actually, and the entire legal structure was one of the main tools used by Israel in order to make this fait accompli serve as objectives. Before talking about the legal system of Israel that was initially made in order to transform the city into a Jewish city, I would like to talk about some changes that were implemented on the judiciary sector because of the control of the far right wing and the right of Israel, led by Benjamin Netanyahu. So the judiciary of Israel historically has been the place where all the leftists were represented, but now it has become with the right. Now the Ayali Chaket is the head of the Ministry of Justice. It is the far right party, and in its program they call upon annexing the area of the West Bank, and they represent more 62% of the West Bank territories that are subject to the settlement agreement. And Abichai Ben Teblet was appointed judiciary advisor of the Israeli government. He is also affiliated with the ultra-religious, and 5 years ago settlers, judges, were appointed in the Supreme Court of Israel. It is the highest court in charge of looking into settlement cases that are presented by the Palestinians before it. And yesterday, particularly Shaked said that she completed the revolution at this court because she appointed more judges that are affiliated with this wing, and this will strengthen the settlement. The right wing does not only control the political arena, they are now in the centers of power and decision making, particularly when it comes to the settlement cases and the expansion of settlements, particularly in Jerusalem, with the support of the government and through private organizations and institutions that are Israeli and Zionist. I go back to the legal structure when it comes to sending the original residents out and transforming the city into a Jewish city. There is indeed a legal structure that serves this project, and they have the law of the property of the people who do not live there in 1950. It was enacted in 1950 by the Israeli government in order to legitimize what was seized the territories after the Nakba, after the creation of Israel. Israel sent the Palestinians out of the western parts of the city and controlled by power most of the properties and the real estate in the west of Jerusalem. There was a need to legitimize this operation, and this is how this law was enacted in order to allow Israel later on to transform these properties and to offer them to new settlers that arrived to Israel in 1948 and even before. The law states that every person who left, who went away out of the borders of the state of Israel that was created in 1948 is absent. So all the property, real estate, houses, accounts, bank accounts are seized or are sent to the custodian, of course part of the state of Israel, and the custodian actually transferred the ownership of the property to Jewish individuals. This way, Israel legitimized its control of West Jerusalem, and it's been attempting since 1967 to do the same in the eastern part of Jerusalem. And this transformation into a Jewish city that took place in the western part of Jerusalem is a complete operation. When it comes to the eastern part of Jerusalem, it's still ongoing. It's not completed yet. In 1967, Israel tries to reinstate what was implemented in West Jerusalem, and the first thing that Israel did was to transfer the Israeli, or to oppose the Israeli sovereignty on East Jerusalem in violation of international agreements and international laws in the United States also. And there was another decision, which is the expansion of the municipality of Jerusalem. And after the expansion, the borders or the surface of Jerusalem became 70 square kilometers. Of course, it wasn't part of a development plan or planning or landscaping. Here in the picture and the image, you can see actually the expansion. So in blue, in red you see the historical Jerusalem, 6 square kilometers. So you can see now the metropolitan city is huge, and it has been used in order, or actually this area that was seized after the war of 1967, and the law of the property of the absent people and a series of other laws was confiscated by Israel from Palestinians. These territories were part of the suburbs of Jerusalem or cities like Bethlehem and other places. And the objective of Israel from the expansion of Jerusalem was to create settlements that surround the Palestinian congregations in the city of Jerusalem for several objectives. First of all, to separate Jerusalem from its historical surrounding and the West Bank, and prohibiting any communication between these settlements. So there were a series of settlements were divided within Jerusalem, and now they had controlled West Jerusalem. They created settlements in the suburbs of East Jerusalem, and they have checkpoints between the two parts of Jerusalem in order to prepare for the creation of a unified Jerusalem, a Jewish unified Jerusalem. Now there are more than 13 settlements in East Jerusalem where more than 200,000 settlers live, and since the presidency of Mr. Trump started, more than 3,000 settling units were accepted, and 1,600 units near Bet Safafa, and 176 units near or in Jabal al-Mukabbir, south of Jerusalem, with the ultimate objective of separating South Jerusalem from its between South Jerusalem and surrounding. Dr. Rasim will talk the coming session about this issue. 2 decades ago, another settling operation took place, which is actually entering the places where the communities, the Palestinian communities live, through associations, ultra-right Israeli associations and organizations supported by wealthy Israelis and Zionists that focus their operation in the communities of the Palestinians in order to prevent the implementation of what was discussed in the Camp David, the Clinton parameters, everything that's Palestinian will be to the Palestinians, and everything that's Jewish will be to the Israelis. And this step was in order to do away with this agreement. On the screen, this image represents actually the triangles show the settlements. I'm sorry, this is not an updated version. However, it gives you a clear image about the situation that was created by Israel. Here you can see that the settlements surround the Palestinian communities in the city of Jerusalem, and now this is Old Jerusalem. You can see it on the screen. In blue you can see the houses that were seized by the right associations in the Old Town and in Salman area, and this is where these associations and ultra-right Israeli organizations operate. They are trying to transform it into a Jewish area, and they consider it the sacred basin, and Sheikh Jarrah, Ras Al Amoud, Olive Mountain, and Salwan city. Here you can see a satellite image of part of the neighborhood of Sheikh Jarrah. It is part of the sacred area of, according to the Israelis, of course, and it reflects a minor part where the settlements were created. Residents of the city can see the changes very clearly taking place when it comes to the property, the real estate in this zone. In red, you can see the historic places of the old city, and you have the city of David, the Olive Mountain, and other areas. And in addition to controlling the territory, Israel has another objective to change the demographics of the city of Jerusalem. My colleagues talked about that, and I would like to delve detail regarding this point. Israel dealt with the citizens in East Jerusalem being problematic since 1967. 1977, and Golda Meir said that she was happy to see the occupation of the Jerusalem, but the dowry was not enough for her. She wasn't happy about that. There were 66,000 Palestinians living in East Jerusalem, and there were no Jewish back then. So Israel dealt with the residents of Jerusalem from this perspective and standpoint. They were subjected to the law of the Organization of Foreigners Entering Israel, occupied the East Jerusalem and would give them permanent residence in accordance with this law. So this reflects the way Israel dealt with the residents of Jerusalem, and it reflects the will of Israel to send the original residents out of this city, and Israel actually adopted this law. The vital city is important. According to the law of Israel, everybody with permanent residency, they are obliged in any moment when asked to prove that their place of livelihood is the city of Jerusalem. For example, if they live in Jerusalem, if they live in Bethlehem or Ramallah, which is very close to Jerusalem, but not living in Jerusalem, they lose this permanent residence and they are sent out. They are prohibited from coming in, and they would need permit in order to enter Jerusalem. This is what was used by Israel, and it sees 16,000 RP from the resident of Palestinians living in Jerusalem, and of course thousands were sent out of Jerusalem. So Israel is also legislating in order to take the national ID out of the hands of Palestinians and residents, and after the separation wall was completed in 2003 in Jerusalem, entire Jerusalem neighborhoods are left outside of the wall, and there are checkpoints organizing the entry to Jerusalem. Around 150,000 Palestinians live there, and they are threatened by the banning or the withdrawal of the RP from them. Although if we see what happened after 2017, attempt to have e-gate, and if they know what the Israeli objectives are, they know that Israel will seize any security or political opportunity in order to take the permanent residency out of these individuals who are Palestinian. The third theme deals with Trump's declaration. Of course, Israel uses every political development to its best interest. Israel amended the Jerusalem as capital city of Israel that was enacted in 1980, just like Dr. Anis said. All the international community were against this law, although this does not change anything practically, because the annexing took place in 1967, and the Israeli sovereignty was imposed even before that. However, I think that this law was to strengthen the fait accompli that was created, and it says that Jerusalem, the eastern and western part, is the capital city of Israel. It is the city hosting the Knesset and the Supreme Court of Israel. There was an amendment in or there was an amendment 19 or in the Article 6 the prohibition of the transferring of powers. It is prohibited to transfer the authorities relating to the municipality of Jerusalem to any foreign party, be it political or governmental. And there was Article 7. There needs to be a majority of 80 members of the Knesset in order to enact this law. What does it mean? It means that any settling in the future with the Palestinians will exclude the city of Jerusalem. Experts know that getting 80 members of the Knesset to agree, this majority is almost impossible. The far right and the right is in control of the political arena in Israel, and it is very probable to get the majority regardless of the final resolution of the conflict. So that was in accordance with what Trump said to Israel Hayyon. Trump said that Jerusalem is no longer part of the negotiation, and removing Jerusalem by Israel from the negotiation. And in addition to that, we have a very clear statement by the Palestinian Authority saying that they will not do away with their right to consider East Jerusalem as the capital city of the future Palestinian state. Therefore, I think the peaceful solution and the negotiations and the two-state solution, as long as the Palestinian position is remains the same, reached an impasse, and I don't envision any scenario according to which any Israeli government could get a majority of 80 members of Knesset in order to amend this law that would allow giving away parts of the East Jerusalem city. Very quickly, I will move to the third theme, which is important. I will be talking about the confrontation options very briefly. I think that working strategy divided into three sections needs to be developed. Locally, within Israel, there are three parts. First of all, we can talk about the political parties, the two sides of the green light. Their role needs to be activated and strengthened in order to face the Israelis through protests as a direct response and as a planned movement against these policies. And when the E-Gate issue took place, the political parties did not take any steps, but the people were ready. The civil society is important. There's a lot of despair because of the lack of political activity was represented or reflected through individual stabbing operations that took place in Jerusalem, the knives revolution that it was called, and also the presence of the Palestinian official authorities that need to raise awareness vis-a-vis the violations and the attempts by Israel to change the situation and creating projects that would support the Palestinians remaining in Jerusalem and working at the level of the Central Council. So the The resistance by the Palestinians needs to continue, and should the leadership be under any pressure to agree to something that is against the rights of the Palestinian people, the leadership needs to be ready to refuse these propositions and to protect the historic rights of the Palestinian people. I think that a strategy of resistance needs to be developed, and we should not give way to the threats, in addition to the activation of the resistance, popular resistance strategy, not only when it comes to slogans, but also as a key strategy adopted by the Palestinian Authority. And the last point is the international community level. I think that we need to present our case when it comes to Jerusalem and the settlement policies, and we mentioned in details how they are in violation of international laws, in addition to the ICC intervening and the International Justice Court regarding the settlement in Jerusalem and the involvement of countries and states and its legal responsibility. Thank you.
Thank you very much, Alaa. We thank all the panelists and for their presentations. Now we open the floor for discussions, questions and answers. Please state your name and affiliation and make your questions pointed, short and concise to have as many questions as we can. In the name of God, first of all, I would like to thank the Arab Center for hosting this important event. My question to Dr. Anib Kassim is made up of two parts. Dr. Anis, in the aftermath of the Trump decision, many legal steps have been taken, and also in view of the American veto at the Security Council, it was said that if the draft resolution included specifically a mention of the United States or the Trump administration by name, then this would have deprived the United States of the right to use the veto. And also the United for Peace decision by the General Assembly also raised questions. Some said that it's binding, some said it's not. And it said that the General Assembly had the right to pass a resolution like that, whereas others said that these are nothing but recommendations and not binding resolutions. And this is what happened. What's your question? Dr. Anis, in your opinion, which point of view do you support? Okay, I think we'll take a few more questions and we'll allow the panelists to respond. Dr. Anis, regarding the Trump decision, he was very clear in what he said in recognizing Jerusalem. He did not say whether he meant unified Jerusalem or East Jerusalem. For this reason, Tillerson said afterwards it's up to the two parties to determine the boundaries of Jerusalem. I think even with the amendments, they left a gap. Maybe they think through this gap there can be future political changes. So they left the possibility of abolishing this law later on.
Question?
Yes, thank you very
Yes, go
much. My name is Mia Swart. I'm from the Brookings Institute, and I have a question for Ms. Karmi-Ayyoub about crimes against humanity. So what I'm curious about is the fact that crimes against humanity isn't, well, as you were suggesting that it's underutilized. Now, in the context of Palestine, I'm just curious, why you think, or I would suggest that a reason why it's underutilized is that in non-war contexts, in the strict non-conflict situation, it hasn't actually been used, in any other context other than, in the context of the international criminal tribunals, where they sometimes recognize that in a particular conflict within the broader conflict, where there's a dispute about whether it was a armed conflict or not, it would apply, right? So it was only really the international criminal tribunals that recognized that crimes against humanity can also apply in a non-conflict situation. But outside that conflict, I haven't seen prosecutions on the basis of crimes against humanity. So why is there that reluctance? And then just very quickly on the apartheid one, that has also not been prosecuted by any state outside. It's sort of very theoretical at the moment. I'm South African, and of course for us it has great significance. It hasn't been prosecuted as a crime there, and it hasn't been prosecuted as a crime anywhere else. So it really seems like the crime of apartheid only has rhetorical significance or very technical significance within the ICC, but we haven't seen it getting a life of its own practically. So I'd like your comments on that. Thanks very much.
Thank you very much. Another question? سؤال تفضل. Microphone.
تحياتي يعطيك العافية مهلا بيت أود الإشارة
First of all, I want to mention the law pertaining to the properties of absent people, which is not applicable only to Palestinians after 1948. It's also being applied to people who live 10 kilometers away from where their land is, in camps like Shafat and others. And this also deprived them from going back to their properties. Mazen Dawla. My question is to Dr. Anis and to Salma. All this talk about international law, my question is rather simple. In the context of Syria and the blockade against Qatar, we do not see a lot of weight to international law. With all due respect for the wonderful things you talked about, how can this be translated into action? Last question. Assalamu alaikum. Dr. Saeed Abdin. My question to Brother Alaa, you said this dossier should be referred to the International Criminal Court and the crimes committed by the Israeli occupation, are they being documented? And has the Palestinian Authority done anything in this regard since 1967? I think we have a good number of questions now. We start with Dr. Anis. So far as the first question by Mr. Mu'taz is concerned, so far as the Security Council resolution is concerned, and the fact that if the Trump decision or the US was named would have deprived the United States from the right of voting and veto, theoretically speaking, this is true, but from a practical point of view and in the history of negotiations at the level of Security Council. This is how it happens. A country proposes a draft resolution which is then will be distributed to the members of the Security Council, and then the proposing country will gauge the reactions by the members of the Security Council. Normally there is a lot of deals that country X will say to the proposing country that if you deleted this word, I'll vote for you, or if you stick to this phrase, I will not. Of course, I don't have precise information as to what happened, but I know for sure this is what happens behind closed doors of the Security Council, and I think the Egyptian representative gauged the reactions of the different countries. At least Britain and France would have voted against the decision, used their veto, if President Trump's name was mentioned specifically. For this reason, the draft came in this general, for this reason, and of course the proposing countries will see the number of countries voting for them. For the Egyptians, the proposing country, 14 for the decision was a victory. Of course, any voting on Palestine will mean that the representative of the PLO will participate, and this is from 1974. So maybe this was the intent, that we get 14 votes for against the United States. This would be a victory. That would mean that this is a vote by the majority of the international community, and when the decision was taken to the General Assembly and for the United for Peace initiative, and this raised a lot of questions. Was this binding or not, the decision? The question is not binding, and the decision taken by the General Assembly under the United for Peace initiative are all non-binding. The only decisions by the United Nations organs are the Security Council resolutions under Chapter 7. If they are passed under Chapter 6, there will be a recommendation. The only binding one will be the ones under Chapter 7. For this reason, it's not binding. It's true, it is presented to the General Assembly as an exceptional measure, will require 2/3 majority, and this is what happened.
128 voted in favor against 9, so it is a quasi-unanimous agreement against the United States decision at the international level. Regarding what was mentioned by Mr. Adib regarding Trump's decision to recognize Jerusalem, Trump did not determine which Jerusalem. He mentioned that Jerusalem is the cradle of the three religions. He actually was implying that he meant the old Jerusalem, East Jerusalem, and not West Jerusalem, because in West Jerusalem there are no religious sites. There are in East Jerusalem, the churches, the wall, and the Al-Aqsa Mosque. Mr. Mazen asked about the value of international law. So what should we do with it? So let's talk, for example, the traffic law here in Doha. It is actually pointless without an execution authority. You need traffic police, you need traffic court, there are fines and there are points deducted from the driver's license. There are authorities in charge of this. The international law is no different. It needs mechanisms and authority. Abu Mazen, for example, goes to the General Assembly and says, we hold the international community accountable. This is valueless. This is pointless. What could you do with this? The international community is not going to slap Israel and ask Israel to create a Palestinian state. You need authorities. The PLO, for example, in addition to the Arab League, they should create these mechanisms, these authorities, in order to create or to set the legal precedent or to achieve the objective. As to saying the international community will not actually lead you to anything. For example, the precedent of occupying Kuwait by the former Iraqi regime. Kuwait was occupied, but Kuwait did not go to the General Assembly and start begging, save us from Saddam Hussein. Kuwait paid money and saved the country. And it achieved the liberation of Kuwait. It did not beg the rescue or the liberation of Kuwait. When it comes to the ICC, International Criminal Courts, this is actually one of the biggest plays by the Palestinian Authority. It actually is reckless by the Palestinian Authority. It is a shame to see the Palestinian leadership to say that they are pressing charges in front of the ICC. No, they are emotionally manipulating people by saying we joined the ICC and the foreign minister presented this or that. President Mahmoud Abbas saw the Attorney General Fatou Bensouda and Fatou Bensouda visited the Palestinian Authority, as if trying to give the illusion to the people that we have movement at the level of ICC. Saeb Arakat says and insists that on a monthly basis, the Palestinian Authority presents reports to the ICC. This is correct. However, all of that is useless. Why? Because the ICC does not move unless the state that is member to the ICC asks for referral. And if the country or the state of Palestine does not request a referral request, all the trips, all the reports of the Palestinian official to The Hague are recklessness and uselessness, and they are trying to give the illusion that they're doing something. Within 3 minutes, please.
Yes, just turning to the second question first. I agree with everything that Dr. Anis said. I would just add, I suppose, 3 points briefly when we're talking about what's the value of international law. I share your frustration that it's essentially, it's not something that is going to have any practical impact unless, as Anis Kassim said, there is political will by states to enforce it, because it's largely a self-executing system. In other words, it requires compliance by states themselves of their legal obligations. However, having said that, I don't think that means we should necessarily abandon it, because I think it can have, first of all, a useful kind of normative value. In other words, it tells us what the standards of behavior should be, and at least it allows us to characterize Israeli actions as illegal and unlawful. And I think that that does lend some moral weight to the Palestinian arguments, and it also lends credibility to Palestinian political claims, most of which can be couched in terms of their lawfulness under international law and the fact that they actually correspond to rights of peoples and individuals under international law. By contrast, Israeli claims don't correspond with international law. They violate international law. So I think it potentially has that useful kind of normative value. I think in terms of actually operationalizing it or making it work for us, the one thing to bear in mind is I think it's just a tool. So it's a tool of many tools, and it has to be part of a broader and more coherent campaign for achieving political objectives. And that campaign ultimately will always be a political one, because that's what we're talking about at the end of the day. But the law can maybe be used as a tool alongside other things. It will never be enough on its own, and I would never advocate that. And finally, in terms of practical steps, though, Dr. Anis mentioned the International Criminal Court. That is an institution that really does have teeth, if only the Palestinian Authority were interested in properly using it. And also national laws. You know, the many international law rules and principles are incorporated into national laws, and occasionally you can persuade a national court or a national prosecutor to act if you bring the claims, civil claims and criminal claims, at the national levels. And there have been some that have almost been successful or have been partly successful. But again, that requires political will, I think. It requires support of a Palestinian national institution of some kind, because those claims require money, the resources, and so on. So it's a multifaceted approach, I think, and law is part of that. Now, just turning to the second question about crimes against humanity and apartheid. Thanks for the question. I mean, it's not something that had occurred to me, that there was a reluctance to think about crimes against humanity in the Israel-Palestine context because of the fact that they haven't generally been applied or prosecuted in situations where there's no armed conflict. I don't know if that's the primary reason. It might be a big part of the reason, but we should remember that, of course, in the occupied Palestinian territory, there is an international armed conflict. It's defined as such, in spite of the fact that many of the crimes take place outside of active hostilities. I've always thought that the reluctance to use crimes against humanity as a framework is to do with the reluctance that exists both on the part of actually the Palestinian NGOs, but also the international NGOs, the UN and the international community, to want to look at Israel as a regime and policies that lead to the commission of crimes that are therefore systematic in nature. Because once you start to look at crimes against humanity, or crimes especially like apartheid, the conclusion you have to draw is that the regime has inherent characteristics which result in the commission of crimes, and that there's therefore something wrong with the regime. It's not just that there's a violation here or a crime there. So that was my view of why there is that reluctance. But I think it would be worth looking at perhaps case studies. The UN might have talked about crimes against humanity in some non-armed conflict scenarios. I don't know, for example, about the Rohingya in Myanmar, if there's been any talk of crimes against humanity there. I just say very quickly, some of the 4 Palestinian NGOs have also made submissions to the International Criminal Court, where they have stated they have framed the construction of settlements and the blockade on Gaza as a crime against humanity. So it will be interesting to see how the International Criminal Court deals with those submissions. And just finally, can I just finish on the apartheid point? Okay. I'm sorry, I know I spent a long time answering. Apartheid, you're right, it's never been prosecuted before. So it's totally novel, it's currently just rhetorical. But I think it's part of a broader theme, which is that Israeli crimes generally are not paradigmatic examples of crimes. They happen in a strange context, in the sense that they happen slowly, they happen often less overtly violently than in other conflicts. And I think this always poses a conundrum for lawyers, which is that we don't have good case studies of crimes committed the way that Israel commits them. It's very special in its capacity to commit crimes in a bureaucratic way. And therefore, that's a challenge. But the whole point about international crimes is they're quite rare, and you rarely ever find two situations being identical. So that shouldn't bar progress on that front.
So regarding the remark regarding the law of the absent property, of course it prohibits the Palestinians from guaranteeing their rights in Jerusalem and the West Bank, even if the Palestinian resides in the West Bank, and this actually is implemented on the citizens of the State of Israel. And very briefly regarding the amendment of the state or Jerusalem capital city of Israel and looking for gaps, we should, instead of looking for gaps, see what the reality is. According to the legal status in Israel, they need a majority, but they strengthened this amendment from 61 members of the Knesset to 80. So it is not a gap, it is in addition to the current legal status, and this law can be read based on the practices of the State of Israel and the political statements. And of course it is clear that the Israelis want to take Jerusalem out of the negotiation, and we should work together in order to face the declaration of Trump. Regarding the third point, it is regarding the documenting of violations. I think that violations are present on the ground, and most of East Jerusalem has become Jewish. There are settlements in all territories that are occupied. There are settlers. In accordance with the international law, it is a violation actually of the international law, and resorting to the ICC is a possibility. Dr. Anis talked about the role of the Palestinian Authority and the importance of that. I don't want to be redundant. I would like to thank you all, Dr. Anis Kassim, Mrs. Salma Ayyoub, and Mr. Alaa Mahajna, and I would also like to thank the Arab Center for Research and Policy Studies for organizing this seminar. Thank you.